Welcome. I think we're live now. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And hello to everybody in between. My name is Dan Balkaran, and I'm going to be your employment lawyer for the next half an hour or so. I am I'm an associate at the, as you can see on the bottom, at the law firm of Samfiru, Tumarkin, Canada's leading employee side employment law firm. Okay, so we are waiting for your questions to roll in. Just a couple of housekeeping notes. As always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca. And I don't have the number with me, unfortunately, but I think it's 1-855, we'll see it in a second, 821, is it 5900? Yes, it is, 1-855-821-5900. Okay, so while we're waiting for your questions to roll in, which should happen any minute now, see if any have come in. Okay, here we've got one from Erica on Facebook. If my employer has written that they can provide, we've got a guest in our Facebook live chat here. That is it's Gandalf, my very old man cat. He's about 14 years old. He joins me for every Facebook live session. Okay, so Eric on Facebook says, if my employer has written that they can provide notice in lieu of severance pay in my contract, does that mean I'm not entitled to severance pay at all? Okay, so this is a good question, and it's a sort of a foundational question in employment law. I'm just going to take you through sort of the logic of how severance works. So it's a bad outcome for society if you're thrown out on the street with no money and no job. So over time, the law has evolved this idea that you are entitled to notice, a heads up, like, hey, Erica, the bad news is you're going to lose your job. We're going to let you go. But the good news is we're not going to let you go for 3 months and whatever the actual period is. And in that time, and then 3 months will be the last day of your employment. But in that time, you can continue to earn a paycheck from us, and we'll give you time off to look for a job. And so hopefully you're not unemployed for very long, if at all. That's what you're entitled to at law, okay? But if you've already been terminated and the employer says you can't come back to work, then of course the notice doesn't apply and you just get paid severance. And so for your understanding, just to make it easy, severance, so notice is the idea like, hey, heads up, and then you got to work for the next 3 months or whatever the period is. Severance is where you just get paid for that period without having to work. Now, 95% of employers, in my experience, choose severance. And the reason for that is because, number one, employees that know that they've been terminated, they're not going to be working at the employer anymore, they can be a sabotage risk. Number two, they can be a morale risk for other employees who are still remaining on with the company. And three, if you give someone the option of, hey, you can work out the next 3 months or 6 months or whatever it is, and we'll just pay you for that entire time and then you're done, or we'll give you 60 cents on the dollar right now in a bag of money, 99% of employees will take the bag of money, even with the steep discount, rather than having to work. And so employers can pay, they can pay less, right? And so that's why they tend to choose severance over notice, although not always. Your only legal right, though, is the important part, is to notice. It's not to severance. So when it says in your employment contract, they can provide you notice or pay in lieu of notice at their discretion, it is at their discretion. So it could be, yes, that you get notice and that's it. Okay, thanks, Erica. Great foundational question. Question from Yasir. Does my employer have the duty to accommodate me if I'm unable to find childcare for a change in my scheduled hours? It's a great question. I have 2 small children. They require me to start overnight shifts. Yeah, I think the answer to that question is yes. It's a tough question. You are in most, like, I don't know what jurisdiction you're in, but most human rights jurisdictions will have some sort of family status, and maybe called something else in whatever jurisdiction you're in, but they'll have like a family status protection. And so that means you can't be discriminated against on the basis of family status. What does that mean? We don't really know. But it has been held in certain situations that if you have young children to care for, then it seems to be primarily for that. If you have young children to care for, they can't discriminate against you on the basis of that. So what I would do, Yasir, is I would, and you may want to talk to an employment lawyer, and it's a good time to say, hey, you can reach us at help@employmentlawyer.ca or 1-855-821-5900, just to get sort of like a fulsome piece of advice and analysis. But I would be totally upfront and in writing with them and say, listen, this is my situation in terms of childcare. I have no ability to care for these children if you put me on this shift. I'm just not able to work these hours. If you put me on these hours, I will, I can't continue to work here because I have to care for these children. And then you certainly would have I think you'd have a good argument under the family status protections of the Human Rights Code. The question then becomes, what is your remedy under the Human Rights Code? Is it compensation for injury to dignity? Is it compensation for lost wages? Is it, are you seeking an order that your employer allow you to continue to or your employer accommodate you with a different schedule? It's always tough, right? Like, especially if you get a lawyer involved, the employer is not going to be too pleased with you. If you can work this out amicably, then you're going to want to do that. But certainly you're going to want to make sure that you put in writing well ahead of time, hey, I can't do this because of the young children. You need to leave me on my schedule or between these hours so I can care for my kids. Make sure that you're sending that information to them in email or by letter or something that is in writing that you can follow by paper trail later if in fact you do have a legal dispute. So sorry to hear about your situation, Yasser, and I hope you work it out. Question from Samantha. I've been working for my employer for the last 7 years, but they have not signed a contract. They're now requiring all contract employees to sign a contract. Am I obligated to sign? This is a great question. I really like this question. So I'm going to answer the question by taking a step back. The agreements between two parties are enforceable at law. It's the biggest area of sort of civil laws is the law of agreements between two parties. When you work for an employer, you have an agreement with that employer to exchange your labor for money, right? Labor goes one way, money goes the other way. And that happens on an indefinite basis. Okay. So it's different than if I were to sell you my bike for $20. So I sell you my bike for $20, bike goes one way, $20 goes the other way, and we're done. Okay. But in the employment situation, money, labor, indefinite. Okay. And so just because you don't have a written employment contract doesn't mean that you don't have a contract of employment. The core of your contract of employment is exchange of labor for money to do a certain amount of duties. Okay, that's it. That's the core of your employment contract. And so what a written employment contract is the contract of employment of, effectively you work a certain amount of hours to do a certain amount of duties for a certain amount of pay. That lives in the air between the two of you, and it's not like completely defined. We know that's part of it, but we don't know what all the terms are. Okay. What a written employment contract is it takes some of the terms out of that, agreement that lives in the air between the two of you and writes them down. So there's certainty of terms. So you're bound by those terms. Okay. And so 99 times of 100, what an employment contract is, because you have certain rights, including very hefty severance rights that are yours that are implied by law into your contract of employment. What an employment contract does, a written one, okay, and I'm being very careful in distinguishing between contract of employment and employment contract. what a written employment contract does is it takes some of those terms out and sets them down, as I said earlier, for purposes of certainty, so that everybody knows, a court knows exactly what you're bound by. The reason why an employer wants to do that, or what an actual written employment contract is, 99 times out of 100, is it's the employer exploiting its superior bargaining power over you at the time of contract formation to impose upon you terms that are contrary to your best interest. Okay. So the reason why most likely they're trying to get you to sign this employment contract is because right now you're entitled to common law severance if you're terminated without cause. Common law severance can be very, very valuable. It can be 1 month per year of service. It can be in excess of that you've worked there in the event that you lose your job. You've been there for 7 years, and I don't know what your age is, but you start getting up 10, 11, 12 years, all of a sudden the company's on the hook for 15 months of severance to you in the event that it wants to move on from you, and it makes it very difficult for them to terminate your employment. And so, the question is, do you need to sign it? No, you don't have to. But if the employer chooses to, it can then say, all right, you're fired, but we need to pay you out severance for firing you, right? So the question is the severance that you would obtain from that worth losing your job? I mean, you have 7 years in the tank there, and maybe you want to stay there to retirement, for example, but although there are no guarantees in life that that's going to happen. So Samantha, I would certainly, I'd take a few minutes, I'd talk to an employment lawyer, I'd kick the tires on this one, and then you can really understand, well, if you say yes, you need that contract that they're giving you. You need it reviewed to find out how it limits your rights. So you need to understand what rights they're trying to limit and how it affects you. Okay. And then number two, you need to weigh, if you don't sign it, what are the options? So the two options are the employer says, okay, that's fine, and just has you continue indefinitely. Or the second thing they could do is to say you're fired. Okay. And so you need to assess whether that's worth it. And how you assess that is what kind of severance you get. Okay. So you should talk to an employment lawyer. Again, you can reach us at helpandemploymentlawyer.ca, employmentlawyer.ca, and 1-855-821-5900. But you should talk to an employment lawyer just to find out and to weigh that balance. I think if I were in that situation, I mean, I don't know what your specific situation is, but I probably wouldn't sign the contract, depending on what it says, obviously. This is the same question. Good question, Samantha. Question from Jared. What are the overtime policies for construction workers? My employers told me that we don't get paid overtime at all. That's a great question. And I don't think I have an answer for you off the top of my head. So construction, some elements of construction are regulated by the employment standards legislation in your area. And then there are some exemptions to overtime. So there's under the ESA, there's managers are exempt from overtime, for example. Construction tends to, in most jurisdictions, be exempt from the termination provisions of the Employment Standards Act, but not necessarily overtime. So to answer your question, I don't know the answer. You can right now, I mean, I can look it up in a fairly short order. I just need to know what jurisdiction you're in. You can send me an email if you like. You can find me at employmentlawyer.ca and I'll look into that for you. But you can also find out the answer really easily. So whatever jurisdiction you're in, provincial jurisdiction you're in, is going to have an Employment Standards Act, which you should be subject to. And because there are so many people who are employed, the public-facing materials of most provinces' Employment Standards Acts they're fairly robust, and so you can look them up, and you should be able to get an answer fairly easily to that question. What you can also do, Jared, is you can ask your construction company to point to the section of the applicable statute or regulation that says that you don't get overtime, and then they can help you out with that. The only thing I'm concerned about, though, with doing that, and what ultimately, as a lawyer, my question is always, what is your remedy, right? Well, if they say we're not paying you overtime, and you say I demand overtime, maybe it won't work out between the two of you guys. sometimes, right? And how much do you need that job? How long have you been there for? What is your career path there? You've got to evaluate all of those things. If you are entitled to overtime under the statute, you can always bring a complaint or whatever it's called in each different provincial jurisdiction. Sometimes they have different names, I think, through your local employment standards. We call it the branch in BC. It'll be called different things in different provinces, but the Employment Standards Authority, you can bring a complaint for your overtime, and they can't technically terminate you because that would be reprisal, but they're most likely you're not going to have a long career there if you bring an employment standards complaint against them. So you got to weigh all this stuff, find out how much overtime you're owed and so forth. Like if you're talking about they owe you $30,000 worth of overtime, well, that's something you got to kick the tires on. But if you're talking about hundreds of dollars, then you've got to weigh it all, right? It's not just what you're entitled to at law. It's what the practical effects of you enforcing what you're entitled to at law could possibly be, and the downside risks from that, and then you weighing what's important to you in a historically tight labor market, right? So you've got to think about all of these things. Like, there's no magic way for a lawyer to make the employer behave in the way that you want it to. And I think like a lot of my clients, and I mean not my clients, but a lot of people I speak to want me to do that. They're just like, well, that's what the law is, so make the employer do what I want. And it's like, yeah, but it's not how it works, right? It's not how the practicalities of business work. So you've got to think, well, what is my remedy? What is my downside risk? And what is the best for me in the circumstances after you figure out whether or not you're entitled to overtime as a construction worker in your provincial jurisdiction. But just go to the Employment Standards Act. You'll find the answer to it. Alex says, my employer had me sign a separate contract for after-hours on-call support. Okay. Contract doesn't provide any compensation for the on-call time unless I receive a call in, and then I am paid a flat rate for a 3-hour block. Is this correct? Should they be compensating me for my time spent on call regardless if I'm called in? Oh, I see. Unless I am called in and then I'm paid a flat rate for a 3-hour block. It's an interesting question, actually. These are all really interesting questions. So if I understand what you're asking, Alex, your employer is, so if you take an on-call call on the phone, you're not getting paid, but you have to go in, then you get paid for a flat 3-hour block, right? Well, so on the one hand, you can contract into whatever you want, right? Like you can sign up I can trade you my $10,000 bike for $20. It's a bad deal for me, but the law is not going to stop us. And so you can choose to contract into whatever you want, provided it doesn't offend other laws, right? So, and the one that it would, I don't know if you're federally or provincially regulated, but there are sort of baseline employee rights that are enshrined. In this case, we'll say it's probably the Employment Standards Act, that can't be offended. And so if you're trading labor for nothing and not getting paid for it, that could offend the Employment Standards Act. And so it could be that you should be getting paid for, it's a really tricky one, that you should be getting paid for your the time that you're answering the phone. In fact, I would argue that you should be getting paid for it regardless of, but depends what's in the contract, but it also depends on what you're actually doing, like the facts of what you're doing. Again, this comes down to exactly what I said to the last person. I think it was Jared. You got to weigh, like, how much money are we talking about? How much of an inconvenience for you is this? And is it worth it for you enforcing what's probably your legal right, which is that they pay you for this time, right? And is this like a super job that you don't want to leave? Or is this something that, you could take it or leave it? It is like, listen, it's a historically tight labor market. So, if employees want to be, in most sectors, so if employees want to be aggressive, now is the time to be aggressive. But you need to weigh exactly how much time you're losing here, or how much money you're out here practically, like realistically, against the importance of the job to you, in case you rock the, like, I can't, like, listen, I don't know what an employer is going to do in any situation. They employers desperately want to keep employees right now. Like the cost of hiring a new employee is astronomical. You've got to get your HR people to market, make all the postings, go through the interviews. Maybe 50% of the time you're going through a recruiter. That employers are paying through the nose for that. Just to get a new employee in the door, you're going to have to pay 20% above market rate to lure them in. Like it's way cheaper to keep an employee than it is to get a new employee right now. And so, you probably have leverage in that regard, notwithstanding, I don't know what industry you're in. And so I would really take a solid look at it. I think that, you got to look at what's in that contract and then what's in employee protection legislation against the facts of your case. This might be one where you want to speak to an employment lawyer. You could probably figure it out on your own though, based on what I've said. But again, you can get a hold of us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, next question from Alex. That's the same question. Carrie asks, how likely is it that the Canadian government would institute a 4-day work week? Would employers be required to adopt this? Okay, so first question is political, and I can't answer that question. I have no idea. Other than to say that the Canadian government, any democracy is, it's a sort of like a weather vane for what the public wants. So if enough of the public in certain sectors want something, then it can happen as balanced against what industry wants, right? So it's sort of a seesaw with the interests of business and the interests of the voting public, right? Because the interests of the voting public can way outvote the interest of industry, but the industry has the money. So, would they institute a 4-day work week? I have no idea. Politically, I have no idea. It's happening, and there are test cases happening in some jurisdictions. Historically tight labor market, it looks like all the boomers have retired due to COVID, or through the pandemic, I shouldn't say due to COVID. And they were the biggest slice of the population pyramid, or at least the working part of the population pyramid. And so, we seem to be in a situation where depending on what the economy is doing, we're going to have a historically tight labor market for, several years, if not at least a decade to come. And so, when we need, and that's going to leave a productivity gap. And so if there's not enough productivity, how does going to a 4-day work week help that problem? I don't know. So I can't begin to assess it. But the second part of your question, would employers be required to adopt this? Yes. If the government, well, it's an interesting federalism question. And I assume it would depend on, so the federal government could enact it for federally regulated employers. I think provincial governments could do it for provincial employers, and it would be the kind of thing that would have to be done sort of jointly together, I would imagine. Provinces often work hand in glove with the federal government. But if it passes as law, yes, everyone would have to do it. So, if you want this, you call your MLA and campaign hard for it. Scott asks, I'm being called back to work as of Monday after being on unpaid leave since February 1 for not revealing my vaccine status. Oh, it's a vaccine question. We haven't had one of these in a few weeks. But I won't be doing any of my old duties. It effectively is a huge demotion to much more mundane duties. Can my employer do this? So this is a really interesting question. So let's just take the vaccine part of it out for a second. If you are effectively demoted, even though your wage stays the same, if your job duties have been hollowed out, the law has recognized time and again that we get human and personal satisfaction from our employment. And so if your job is eviscerated and the prestige and duties of it have been eviscerated, that you have effectively been constructively terminated by the actions of the employer. Okay. So in a normal situation, I would say that depends on the facts, right? Like, so you got to have evidence. You got to marshal this properly, because if you trigger a constructive dismissal and you're wrong, you get 0. Okay. So of everyone I've talked to today, Scott, you're the one who most needs to talk to an employment lawyer. if in fact you want to pull the trigger on a constructive dismissal. Now, why would you do that? Once you get to termination, you're entitled to severance, and that severance is so employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Once you get to termination, you can get severance. Now, your severance is contingent upon what your employment contract says and other factors like your age, your length of service, and your position. Okay, so you need to understand, if your severance is limited to, just the statutory minimums, probably don't want to do that. But if you have 24 months coming to you at the top end, obviously, then certainly it's something you got to kick the tires on. So you're definitely going to want to talk to an employment lawyer. Now let's reintroduce the vaccine question. So this is a fraught issue right now in Canadian employment law. We don't have any certainty on it yet. I'm of the opinion personally that an unpaid leave is just a fudge to get around your rights at law. You can't just magically create a status, say you're on unpaid leave, but we're not going to pay you for it. That's just a termination. It's a termination by any other means. I'm also of the opinion that requiring someone to get a vaccine to continue working somewhere, notwithstanding the medical importance of vaccines, but saying to somebody, you need to get a shot to continue to work here, that's introducing a new term of employment. At least that's the way I look at it. And so in order to do that, you need consent and a fresh consideration, at least fresh value, we'll say, to make it a term of your employment. And therefore, if those things weren't provided, they can get rid of you, but they're going to have to pay you severance for it. Now, this is an open question. The other side of the argument is that, well, no, it's not a fresh term of employment. It's that employers are required by occupational health and safety legislation to have safe workplaces, and instituting these policies, vaccine policies, are reasonable to meet those statutory obligations. If the courts decide this based on that argument, then it's going to import sort of medical reasonableness, which 93% of the population is vaccinated, and so the culture, particularly the sort of the what's the word I'm looking for, the credentialed classes that sort of make legal decisions, we'll say, they're all rowing in one direction. And so you've seen a number of arbitration decisions that have found these policies to be reasonable. But I can't get over at law how serious it is to say to somebody, you must put this thing in your arm or you can't feed your family, right? And how that to me is a fundamentally new term of employment that needs fresh consideration for, and you certainly can't just fire someone without paying them severance. So long story short, Scott, is it a constructive dismissal? It depends on the facts. Does the vaccine stuff, your refusal to just declare your vaccine status and then the change of your position reduce your legal position? Yeah, I think it probably does. And so, you got to, but we don't know the answer to the degree with which it does because of everything I just talked about. So talk to an employment lawyer for sure. I'm going to try to get through. We have two more questions. We're pretty much out of time, but I'll try to get through these for you. So Shauna asks, what does it take to prove a wrongful dismissal? My employer has made allegations against me that are untrue and let me go based on this without any severance. My feedback for all this was positive. Okay, so you were terminated for what's called just cause. As I said earlier, it's a bad outcome for society for you to be thrown out the street with no money and no job. So the law has evolved this idea of severance. The law wants you to get severance. However, there are certain situations where the employer is legally permitted not to provide you with severance. And so we call that just cause, where just cause just means we can terminate you without providing you any money or notice. And so there are 4 ways to get to just cause. A single act that's so egregious that the employer can no longer continue the employment relationship. An ongoing series of performance failures or conduct failures, which you provide clear warning of and an opportunity to correct. And sort of cumulative cause, where you've you're just an all-around bad employee, harder to make out the longer you've been there. And the fourth one, I don't want to get into right now. So it just, unfortunately, so it's a high bar for the employer to get there. They're the ones to have to prove that they had just cause to terminate you, but it doesn't mean that they don't have it, depending on, right? So what was your infraction, right? The core of it is the relationship of the trust between the parties completely broken down. So if you stole something, even something as benign as a roll of toilet paper, I say that because I had a colleague years ago who did that. When I was 17, working in sort of a retail environment, that's enough. You can get fired for that, and for just cause, and it was theft, and that was it. But if it was a mistake, like you made a mistake and it cost the company some money, that's probably not going to get them there unless there was a repetitive component to it. It depends on what the infraction was and the severity of it. A single infraction certainly can get you there. Lying, dishonesty certainly can get you there. But Shauna, you need to talk to an employment lawyer. Again, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. And last question from Sue. If I've finished my shift and clocked out, can my boss still require me to do 15 more minutes of work on each shift I work? Well, I mean, if you're an hourly employee, subject to the protections of either your employment contract or whatever applicable legislation, most likely the Employment Standards Act, no, it has to pay you overtime. But again, this comes, there's famous cases of big box stores all over the US and Canada doing stuff like this to try to squeeze out a little bit of extra labor without paying people. And they know in those situations, their employees are incredibly vulnerable. And if the employee fights back, they could lose their job, right? So that's the evaluation you have to make, right? It's practical advice or practical, you got to evaluate the practicalities of the situation. So if you push back, what's going to happen? Well, you're certainly not going to be on a promotional path. But it depends on the industry too, right? Like, if a lawyer said, "Oh, I'm sorry, I can't work the extra 15 minutes you're asking. I need overtime pay for that," that lawyer would be out of that firm so fast you wouldn't believe it. So it just depends, right? It depends on your situation. But if you're a labor employee working hourly, no, they probably have to pay you. But do you really want to rock that boat or not? Depends on your situation. And right now, again, I keep going back to it. Historically tight labor market. Every single store you pass has got a sign out front saying we're hiring. Nobody can get workers. So if you ever have leverage, now is the time. Okay, so or if you're ever going to have leverage, now is the time. So something to think about, certainly in terms of, when employers are trying to pull fast ones on you, or you have a legal entitlement to something, but you're not sure if you should enforce it. So all those were great questions. I hope I got, all the answers you needed for the most part. I'm going to be back in 2 weeks. At least I should be back in 2 weeks. I do have a holiday coming up. Oh, Monday. Look at that. Monday, July 25th. Join us 1:30 Eastern time for Chris Justice. He will be bringing the justice to you and all things employment law. Come join us for that. He's great, and he'll answer your questions. And then join me in 2 weeks. I'll be back at 2 weeks from today, I believe, and then I think I missed the next session after that, but I'm not 100% sure. But join me in 2 weeks, every second Friday here at this time. And as always, you can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Thanks for all your questions. They were wonderful. Have a great, fantastic, and safe weekend.